set of laws. The first one being our Constitution, the second being the Fair Administrative Action Act, the third being the prevailing case law on this specific matter we are placing before you, the fourth being your standing orders, and the fifth being the rules of this committee itself. And it is our submission, as I hopefully show you shortly. Whichever of these regimes of law, and I've mentioned them in their hierarchy, whichever of them you look at, there is zero room for introducing extraneous material that was not part of the documents that were before the House when it appointed this committee. We'll begin with the Constitution, Honorable Chair and members. Article 50 of our Constitution has a right called fair trial. This right, Honorable Chair, includes, among other things, the right to confront and to respond, and more importantly, when you read Article 50, subparagraph 2J, the right to have the information and the allegations and the evidence against you in advance. Those are not my words. It is the words of our Constitution. The evidence must be submitted in advance so that, as a matter of fair trial, the person accused will have the opportunity to respond to all the allegations against him. This matter of fair trial is so important, Honorable Chair. It is one of the three rights in our Constitution that are absolute, which means they cannot be limited. This can be confirmed from Article 25 of our Constitution. It lists certain fundamental rights which cannot be limited. Not even Parliament can enact a law to limit those rights, and one of them is the right to a fair trial. This right is as old, Honorable Chair, given the type of legal system we have. It is as old as the year 1215, more than 800 years ago, when we had a document called the Magna Carta. Article 47 of our Constitution again talks about the right to a fair administrative action. I only mention this, Honorable Chair, because the communication from the Speaker to this committee said a number of things. One of them, of course, was that these proceedings are quasi-judicial, but for purposes of my submission, the Speaker also said in his communication to the House that the proceedings before you are governed by the Fair Administrative Action Act, which is the one that governs this whole question of fair procedure and whatnot. That brings me to the prevailing case law on this matter, Honorable Chair. Luckily, we are not bringing to you a matter that is new. This matter has preoccupied our country to a level that we had to appoint a 5-judge bench of the High Court sometime in 2015, when the Republic of Kenya at that time, beset with terrorist attacks, wanted to change the law on inquiries and criminal proceedings so as to tinker with this right to fair trial so that the state could go to a court of law and introduce the evidence right at the eve of the trial, right at the very 11th hour. And we have a decision, I believe, petition number 628 of the year 2014. I said it's a 5-judge bench decision. And the issue in that case, which likely my senior, Dr. Camino, was actually the one arguing this point, and the court was happy to agree with him, that it is not permissible, even when the country is faced with the existential threat like terrorism. You cannot do what the mover of the motion now is attempting to do, which is to bring a motion to the House, have the motion approved by the House, sent to the committee, and then...
Madam Chair.
Yes, Honorable.
May I just inquire if we have this ruling before us? Is it in the bundle? Which bundle? Please point to us where it is.
The Honorable Chair have endeavored to print the relevant parts of that ruling. We didn't have it, of course, in advance because we had not noticed until last night very late that this issue would arise, because we were working on the assumption. I've just given to the Secretariat. It's a fairly long ruling, so I only bothered to print out the relevant parts, and I think it is highlighted in the document. It is a paragraph 346. And all we are saying, Honorable Chair, it is not every day problems like this our Chief Justice appoints a bench of 5 judges. Usually the practice is 3 judges, but this was a matter that was so critical to the administration of justice in this country that the CJ had to constitute a bigger bench than usual of 5 judges. And the matter was settled. It is not a question of discretion. It is not a matter of us trying to balance this or that. It is there in black and white from the High Court, which is the court charged with interpreting our Bill of Rights. And all we are saying is that it is not permissible. And the reason it is not permissible, Honorable Chair, I told you this matter is as old as 800 years. Back then, there used to be controversial methods of inquiry in which evidence was withheld until the last minute. People used to be tried before an institution called Star Chamber using very unorthodox means. In short, trials 800 years ago used to happen, for lack of a better word, if I may say, where the accuser would keep surprising you, like a conjurer pulling out rabbits from his trench coats. And because this matter was so critical, Honorable Chair, it was the subject of revolutions in England. No less than 3 revolutions. In one of them, the monarch actually lost his head. And all we are trying to do is to tell you, it is not possible. It does not even arise for consideration. Lastly, Chair, you have your standing orders. Standing Order 64 says that by the time the motion comes to the Speaker for approval, it should already be accompanied by the witness statements, by sworn statements, and all other items of evidence. Those are not my words. The thinking must be that by the time you make an allegation as serious as the ones before you, you had better have done your homework, you had better have done all your preparation, and you had better put forward all the material upfront so that the accused person will have then the opportunity to respond. And of course, your rules themselves, which is Rule 2, if I'm not mistaken, I am being guided by Boniface that I might be mistaken, but you've already adopted the rule again. Rule 7, consistent with your standing orders, which says that, if I may read, in presenting evidence, the sponsor of the motion shall not introduce any new evidence that was not part of the allegations against the Cabinet Secretary. And very lastly,
try to conclude.
Yes, to conclude, Honorable Chair, there is a further practical difficulty we have with these so-called witness statements. As I told you, we were only told this last evening. The Cabinet Secretary is unable as we speak to confirm whether, one, the so-called witnesses are persons who actually registered for the fertilizer program at the inquiry, whether as a matter of fact they obtained fertilizer and from which depot and on what date. So we are completely unable, even if we so wished, given the timelines we are working on, to respond to whatever those witnesses may purport to say. And the very last point, Honorable Chair, you must be told what was the difficulty in putting up these witness statements, in getting these guys to swear their witness statements according to Standing Order 64 at the time the motion was brought before the House. I have not heard them attempt to tell you either these people were nowhere to be found, we're trying to trace them, we couldn't, one of them was in hospital or something like that. No reason has been advanced why there was non-compliance with Standing Order number 64. On the contrary, what you have is a mover that assumes, like I kept saying last night, they have a right as a matter of course to keep pulling these surprises. And for those reasons, Honorable Chair, we urge you to reject that request for additional witnesses. We will deal with the question of the defective affidavit, given that I've already run out of my time. When we respond to the case, I will still beseech you to give directions on the other requests we had made, which are in writing anyway, and on the questions of summons. The parties cannot be the ones requesting you to summon anyone. It has to be the select committee exercising its own independent mind to decide we need to hear from so and so. It cannot be me, it cannot be my learned friend telling you or insisting or pushing you, summon so and so. Because a person summoned is not a witness of the cabinet secretary and is not a witness of the move of the motion. They are just someone summoned by the committee to enable it to understand something. Thank you.
Thank you. Honorable.
I'll kindly ask my lawyer to make just a brief statement about that.
Okay, may I praise you, my lady. My lady, the issue before the Honorable members of the Select Committee is a national issue of considerable gravity. And the objections that are being raised with tremendous respect to my land friend, they do trivialize what has been placed before them. And I urge you very respectfully, the members of the committee, that my land friend will have to be controlled. Otherwise, we may not be able to dispose of the matter before you within the timelines that have been given at all. If I may very respectfully refer you to the Constitution, which my land friend is relying on, and which he has been emphasized very much. Your Honor, if you look at Article 1, Article 1, Sub-Article 1, Sub-Article 1, says, sovereignty of the people. All sovereign power belongs to the people of Kenya and shall be exercised only in accordance with his constitution. And 2, which is perhaps more important than what I've read to you, the people may exercise their sovereign power either directly or through their democratically elected representatives. It is now democratically elected representatives who are seized of this matter. And they cannot be controlled, or the issues that are before the court, before this select committee, cannot be washed or swept under the carpet by raising trivial objections at all. It's my humble submission that you overrule my learned friend. You don't have to waste time. And in doing so, you'll be guided by the able ruling that was delivered by our Speaker on 30th April 2024, which is before you. I don't wish to waste most of your time, or much of your time at all. I would prefer that we get on with the job so that we meet the timelines and we are able to proceed with the matter before you. Finally, I may point out that my learned friend, from what I can see, is trying really to buy time so that we do not finish this matter within the stipulated timelines we have been given. That's all.
Thank you.
Madam Chair, out of curiosity, if indeed the minister is innocent, why is he worried about the witnesses? This is a matter of national interest, as my lawyer has said. If indeed you are innocent, Kenyans want to know. Could be someone is trying to bring witch hunt to the minister. Let us be allowed to bring each and everybody who will set him free. The jury is in the public. Bwana Minister, relax. Let Kenyans.
Honorable Wamboka, we are just beginning the process, and please do not rush to the conclusion, and limit yourself to the time that we have given you. And may I also advise all the other parties to adhere to the time allocated during the hearing, and also the witnesses that should note that they cannot go outside time allocated to each party. Again, it is important to note that the witnesses' submission must fit within the time allocated. If we respect that, then we'll be able to conclude on time. Now, I would want to take this time to give the ruling as per the requests that both the parties made last evening. Honorable members, given the Constitution timeline within which the committee must conclude this process, the detailed rationale behind the decision on the preliminary issues and questions will be elucidated in the committee's final report. Having said this, on the preliminary issues that the affidavit is defective, we have overruled the preliminary objection, having looked at Article 152(7) of the Constitution and Standing Orders 47(4)A, 64 and 66. Number 2, it is noteworthy that it is the exclusive authority of the Speaker of the National Assembly to determine the question of admissibility of a proposed special motion for dismissal of Cabinet Secretary, a matter that was already determined. We are now at the stage of investigation by the committee, the question of admissibility having been determined by the Speaker. Number 3, consequently, I direct that committee shall proceed to hear the matter and discharge its mandate as required under Article 152(7) of the Constitution. Number 4, as stated earlier, we shall give a detailed and reasoned ruling in our report on this matter. The question, can we admit new evidence? Honorable members, and does not prescribe the specific evidence to be presented before the committee. Number 2, what is important is that these investigations by this committee should and will not go outside the allegations in the special motion. Number 3, consequently, the committee shall allow any party to invite witnesses or produce new evidence, provided that the evidence strictly relates to the allegations contained in the motion. Number 4, the committee will not entertain any witness or evidence that is not relevant to or that purports to introduce new allegations outside the allegations as passed by the National Assembly. Number 5, we shall give a detailed and reasoned ruling in our report on this matter. Can the committee summon, can the committee summon the Principal Secretary for the State Department for Agriculture and the Managing Director for KELS Chemical Limited as requested by the sponsor of the motion? The response: Article 125 of the Constitution, Section 18 of the Parliamentary Powers and Privileges Act, Standing Order 191, and our own rules of procedures gives power to this committee. Wanami Wamboka should first provide the evidence for laying basis for the request so as to demonstrate the need for the exercise by the committee to summon the Principal Secretary for the State Department for Agriculture and the Managing Director for KELS Parliamentary Powers and Privileges Act, Standing Order 191, and our own. Having said this, Honorable Wanami Wamboka should first provide the evidence for laying basis for the request so as to demonstrate the need for the exercise by the committee to summon the Principal Secretary for the State Department for Agriculture and the Managing Director for KELS will take 40 minutes. Cross-examination and the sponsor and the Cabinet Secretary we have given 60 minutes, and the rest of the witnesses 20 minutes. Closing statement 1 hour. The parties are, as I said, the parties are accordingly guided, and we will proceed.
Much obliged, Your Honor.
Thank you. Opening statements by Honorable Wamboka, and you have 40 minutes, sorry. As I said, we have allocated 40 minutes, and please be guided by the clock on the left, on our left, and on your right.
My 40 minutes, I'll give some remarks and I'll allow my advocate to say something. This is a case of gross violations of the Constitution, gross misconduct, and ministerial responsibility. The national agenda of this administration, William Ruto, security is noble. And from the onset, I must say, we support the president because agriculture is the backbone. If the country is food secure, then you have a healthy nation. It is too critical a matter for this country to be realized. Madam Chair, this motion highlights various violations meted out against innocent citizens through distribution of fertilizer as we demonstrate. Consumer rights have been elected, and someone must be held accountable. The Ministry of Agriculture and Livestock has gone ahead. We must take responsibility. In fact, in serious democracies, by now, the minister should have resigned. This is one of the flashes. And as I said, we support the president. And that is why I'll draw your attention to the voting in the House. Honorable Chair, it was bipartisan. It was bipartisan. That is how serious this matter is. I've looked at the responses from my good friend, and indeed is my friend, Linturi. There is a Luya saying that says, I would wish that this should become this, so that I don't listen to what the Honorable Minister is trying to say. That, Honorable Chair, 149 members of Parliament, and indeed those who were in the House that day, will understand that there were more people. Cards were not working, and the Speaker ruled on this. 19 members, including the Honorable Nabila Bora, my good uncle, the Honorable Michomba, they did not vote. 19 members of Parliament who supported this motion and who were in the House did not vote. It should be understood that 24 members of Parliament were out of the country, had petitioned the clerk of the National Assembly if they can vote virtually. 24. Those members are going. It is incredibly unserious. Honestly, a whole National Assembly saying something is wrong. Something is wrong. And it will be very, whatever happens to this case, it will be very, it will be not business as usual. Because that voting, it was a vote of no confidence to the minister. It has consequences. I would be keen to imagine how ambassadors will be dealing with it. Our good friends on high moral ground, the United States, the EU, of which we shall be appealing to them. But indeed, the National Assembly has passed a vote of no confidence. In that alone, it speaks volumes. It speaks volumes. And I think the minister has guts even to be here today. This motion is not about me. This motion is not about the National Assembly. I had some good friends in Meru saying we are targeted. No, we have very many good Merus, including my good friend, who is at times my lawyer. He's a good Meru. He's a good Meru. It's not about Merus. Merus are good people, and I want it to be understood in this committee. It is not about Kenya Kwanza. Honorable Chair, it's not about Azimio. It is Honorable Franklin Mithika Linturi versus the Republic of Kenyan Farmers and Diaspora. I did indicate I come from a border town. Ugandans buy things from Kenya. Kenyans buy things from Uganda. My good sister would know this. Mahayo, the Iron Lady, would understand this. The Ugandans came and bought fertilizer from Kenya, subsidized. What should they do? What what should they do? I looked at the document submitted by my good friend Linturi, and it's nothing more than a love letter from a jilted lover. That these are grievous matters of national importance to be reduced to love matters. Ukiachwa hachika. It is indeed unfair to keep dragging the good lady, my sister Marianne, into these matters. She has a right kukukata, kukukubali. Allow her to proceed on with her life. And I'm sure the Kenyan ladies are taking offense of this, including the Honorable Chair, that it should be unfair that your private matters should keep coming up anytime serious matters are raised. The good lady should be left in peace because she has a life, she has a family, she has children, and she needs to move on. We shall speak. This is a select committee. We shall say that which we want to say and that which we think is important in this committee. I did indicate yesterday that very many people approached me to drop this motion. I refused. And in fact, I told one of them, I'm different from the Honorable Linturi. It should be understood, Honorable Chair, that the Honorable Linturi started a process such as this. This was going to be the second one in the new constitutional order. Had he been serious, he went ahead, he collected signatures, it was put on the order paper, his motion. What did he do? He went to Naivasha, was given money and love. That indeed it is a demonstration.
Yeah, I have a point of order. Point of order by the Honorable, we've made it very clear that any statements made by a witness, a sponsor, or a respondent must be substantiated. Allegations have been made about going to Naivasha, money being exchanged, and unfortunately we do not have any substantiation on that. Let's not use this opportunity to malign one another. I think we should also speak up and we must see one another.
Honorable Chair, it is indeed in public. It is indeed in National Assembly records that a motion to impeach one Anwai Guru appeared on the order paper. It is indeed in records of the courts. In the divorce case of the Honorable Franklin Mithika Linturi and Aldai Member of Parliament, Marianne Keitani, as to where the member...
Honorable Wamboka, I think you should limit yourself to the subject.
Well guided, Chair. But Madam Chair, I'm a serious Kenyan. I had to do this, and I have done this. Those who don't know, I'm defined by Bayaya, Bala, Banyangali, and Batachoni clans. That definition, those sub-tribes cannot allow me to be bought, cannot allow me to be subverted. That is why we're here. It's because I'm serious, and I will die for the farmers of Kenya. The Honorable Minister has dragging me in dragging strangers in the name of my alleged affairs, which cannot negate the fact that innocent Kenyans are suffering. I would want to understand by you saying that so and so is Jack's wife, is the honorable member's wife. How does that relate to the suffering of Kenyans? How does that relate? And if indeed honorable chair of Justice Committee is fair, is only seeing one side when we speak, why should the minister bring no, I'm reacting. It is in his submissions.
I don't want this committee to be turned, this investigation to be turned into love affair investigation. Please limit yourself to your motion.
Yes, Honorable Chair, but it must be noted and be on record that in his submissions.
Yeah, point of order by Honorable Rachel, Dr.
The Chair did not intend to interfere with statements that the Honorable Mboka is making, but I would like to raise a matter on Standing Order 77 concerning the language that we use. And 77 says, all proceedings in the House shall be conducted in Kiswahili, English, or in Kenyan Sign Language. Twice, Honorable Chair, the Honorable Mboka has mentioned words in a language that we did not understand, and I thought that he was going to translate so that we can understand. This may make us miss some of the information that you would like to tell us. So is it in order for him to use that language, which I'm not able to tell which language it is, because we are not able to understand that particular portion?
I'm sorry, Madam Chair. What I meant is I would wish that my ears become my sitting apparatus so that I cannot hear all this. That's what I meant. But well guided. Madam Chair, I've got one wife, which is public knowledge. This is not a forum to bequeath me with imaginary wives. And in any case, does it matter? I'm on this honorable chair because he brought it. If you look at his submissions, it's there.
Point of order, Chair. Point of order by Honorable J. I believe it is very important that if you make a ruling, the Honorable Member understands that you are directing him on what to confine himself on. And Honorable Chair, if someone disregards that ruling, then you should be able to also call them out of order.
Well guided. Well guided. Well guided. But just to note, this is not a divorce case. Madam Chair, we are discussing the conduct of Honorable Mithika Linturi, that we want him removed from the office. Out of this world, I was just imagining, when he was being interrogated to the minister, he said he has in excess of 30 cases in court. We have Kenyans, members of parliament. Why him? Why him? Why him? We are speaking. We have a saying in Luo land. The hyena told the stone. You remember the case of J.M. Karuki when they were investigating his death. Mwangale told his house, so House of Records.